I'm not the instructor for today's class. Today's class, or today and the next class, the two classes here are about intellectual property. It's a topic that is of great importance both for entrepreneurs and for intrapreneurs within a large company. Innovation people do, but they forget that they need to protect their innovation and not let somebody else come into this space. I cannot think of anybody better than Professor Raj Hirwani to take all of you through this important topic of intellectual property. Professor Hirwani has over 40 years of experience in IP. He used to be the Director General of the IP cell of CSIR. CSIR is the Council for Scientific and Industrial Research. These are actually the public sector labs from which several innovations in India have come up, and Professor Hirwani has personally been involved with how to, on the strategy of intellectual property as well as the policies, and the policies of the Indian government on these are very friendly towards entrepreneurs. I also know that IP policies of the higher educational institute that all of you are a part of have also become quite friendly. So please understand from Professor Hirwani when he talks about trademarks and patents and trade secrets and everything else, what is the best way that you have of perhaps protecting the innovation and inventions that you are doing. My suggestion to all of you, my learners, would be that you bookmark this lesson, these two lessons, because if you do not have an idea in your mind right now, some of this may be a little theoretical for you, but the moment you have an idea that comes to you, you will start thinking about how to protect it. You can't protect an idea, which is one of the first things Professor Hirwani will tell you, but please do bookmark these two lessons so that you can refer to them at a later stage. I present to you Professor Raj Hirwani, and the topic for the next two lessons is intellectual property.
Welcome to this session on intellectual property for a startup. Before we speak about intellectual property, let us talk about what the startup is. Startup is basically an enterprise engaged in early stage technology where outcomes are still undetermined. We do not know which direction technology will take, what kind of products will be made, for which markets and what applications. Proof of concept is yet to be demonstrated. You therefore need a continuous involvement of the inventor. And very often no market exists or very little market exists. You may have to create the markets. And sometime legal or other changes may be required to enable adoption. Those changes may be regulatory or procedural. And established players are unlikely to take risk because they are not sure about the markets and profitability. And on top of it, if inventors themselves are interested in taking innovation to marketplace. Once you go through all the hard work, at the end of that, if you succeed, what you have is some information, some know-how, some technology, which are basically intangible assets. You do not have production facility, you do not have distribution network, you do not have godowns, warehouses, anything. Your value is in that intangible property. And once you succeed, the likelihood that other peoples will start copying you. Now you need to stop those people because you have put in all the hard work, all the resources. This is where the intellectual property comes into place. When we talk about intellectual property, we have to understand the basic concept of property. Where you own something, you are free to use as you want it, and you exclude others from using that owned item of property. Your house, you're not living into it. You want to keep it locked. You don't want to even give it on rent. It is your freedom to do whatever you want to do. Now, this concept of property, when we apply to the creation of human mind, that is the intellect, is called intellectual property. Intellectual property is today a bundle of rights which are segregated into different categories. One is literary, artistic, and scientific works. You write books, you write poems, you write drama, you make a lyric. Protection of all this property is governed by the laws which are called copyright. Then are performances, broadcasts. Gulzar writes a lyric and Lata Mangeshkar sings. She brings it to the public. You may write a drama, you will get a copyright. But there are some people who will come and perform on the stage. They get what is called a performance right. Lata Mangeshkar's performance right is related to Gulzar's copyright. Because Gulzar gets a copyright on his lyric and Lata Mangeshkar gets a performance right. Her performance right is related to Gulzar's copyright. Therefore, it is also called related rights. Then third most important intellectual property right deals with inventions. It may be a new form of a jet engine, new drug, new pesticide, new vaccine. Protection of these inventions is covered by laws concerning patents. Then comes industrial designs. As an engineers, when we talk about industrial designs, we talk about the functional aspects. But for the purpose of intellectual property, industrial design refers to the aesthetic aspects, how the product looks like. It has its own specialized laws called as industrial design. It is also called industrial design registration. Then we have trademarks, service marks, commercial names and designations. Trademarks are basically associated with products. When you apply trademarks to a service, they are called service marks. There is a new form of intellectual property right, which is called geographical indicators. It is given to products which come from a certain unique geographic origin and have certain properties which are due to agroclimatic condition in those regions. Therefore, they are called geographical indicators. If you have champagne, it is made from the vines which is grown in the Bordeaux region, which is part of the France and part of Germany. When you talk about basmati rice, you are talking about rice grown in certain northern part of India and part of Pakistan. When you say Darjeeling tea, you are talking about tea grown in the Darjeeling district of Assam. You can't call Kangra tea, which is grown in Himachal Pradesh, as a Darjeeling tea. Then there are electronic devices. All of us have gadgets. They have technical design of integrated circuit, PCB layouts. These are covered by a separate international treaty called Washington Treaty. Then we have new plant varieties which may be produced by conventional breeding techniques or by biological interventions. These are protected by Plant Varieties Protection Act. Biotechnologically modified plants can also be protected against patents. Then we have confidential information which is not in public domain. It is kept as a secret, so they are called as trade secret. So this is a bundle of intellectual property rights. Now, why do the IP rights matter? First and foremost, they give you exclusive rights. So you can create a barrier to entry of competitors. So you protect your business and inventions from your competitors who may try to reverse engineer it, who may try to copy and get a profit from the market for all the resources which you invested in creating those products. Because you have exclusivity, you get a higher market share. Another important point is you avoid the risk of being exposed to assertion by infringement by competitors or third parties. If you do not have your own IP, it is possible other people may sue you for the infringement of the IP which they are holding. If you have IP which you are not using it, you can license to others. So you can monetize by getting income from royalties. And if you have an IP, you are able to attract investors. In a high technology game, nobody can say with certainty whether technology will succeed or not and which direction it will take. So investors are in that uncertain climate. When you have an IP, they have some assurance that there is something of value which has been protected. So even if you don't succeed, they may be able to salvage some value of that asset. That is the reason investors look for IP. Now let us look at IP rights which are important for startups. One is patents, second is trademarks and domain names, third is copyrights, fourth is design rights, trade secrets, and other items like data, know-how, mass works in the case of semiconductors, chips. And if you are in agriculture related things, then also geographical indicators will become important. Now let us look at each one of these rights independently. Now what is a patent? Patent is a right granted to inventors to prevent unauthorized use of an invention within a particular territory for a limited time. I made 3 words bold here: prevent, particular territory, and limited time. I am going to explain each one of them. But before I do that, let me tell you, just because you got a patent, you do not have a freedom to exploit your invention. You can't assume that you are free to make, sell, and make money. It is a right which only enables you to stop others from using your invention. So this is basically a negative right. It is only enabling you to stop others. It is not saying you are free to use your own invention. Why it is so? We will come shortly. Patents are territorial. Patents are granted by the government. Government of India cannot give you a right which you can go and enforce in United States. US government cannot give you a right which you can go and enforce in Japan. Any right given by any government is restricted to its own territory. So an Indian patent has no force in other countries And similarly, foreign patents have no force in our country unless we go and apply and get the patent in the foreign countries, and the foreigners apply and get the patent in India. Lot of SMEs come and talk to me, say, here is a US patent. I ask them, is there a corresponding Indian patent? If it is not there, you are free to use that patent within India or wherever the patent is not there. But don't export the product to US, because the moment it lands in US, it will be infringement. Patents have limited validity. They are valid 20 years from the date of application once they are granted. After 20 years, the information is in public domain and anybody can freely use it without any obligations to you. Let us now come to the positive right. Why you do not have a positive right? It is possible that you may get restricted by the previous patents. In the same area of technology or products, somebody else might have taken patent before you, and your patent may be extension of his work. You may be building upon his patent. He got a right to exclude others. In his others, you are included. So you are basically infringing his patent. So you do not have freedom to operate, freedom to market, or freedom to practice your patent. Let me give an example. Everybody believes the light bulb was invented by Thomas Edison. He did not invent the light bulb. Light bulb was invented 10 years before he brought the light bulb to the market. Another gentleman, Mr. Henry, had conceptualized the bulb, had made the prototype, and shown that the concept works and had taken the patent. The disadvantage of his invention was the tungsten filament used to burnt away in few minutes. If the filament gets burnt away in few minutes, you can't have a commercial product. But once the patent was published, people looked at it and said, what a great idea it is. If it works, it will revolutionize the lighting industry. So people started working on different materials and different processes. While doing that, they got the patents. What Edison succeeded was having a tungsten filament which lasted for 1500 hours. He got the patent. Now the question is, does the Edison has a freedom to make the bulb and sell the bulb? The answer is no. He did not invent the light bulb. Light bulb was invented by Mr. Henry. Edison's invention lies in the tungsten filament. If he makes the light bulb, he would infringe Mr. Henry's patent. In such a situation, there are only two possibilities. Mr. Henry takes a license from Mr. Edison and makes a bulb and incorporates a tungsten filament, or Edison takes the license from Mr. Henry and makes a bulb with a tungsten filament. And that is what the Edison did. Edison took a license and then made the light bulb. Since Edison was the first person who brought the bulb to the market, his name got associated with the bulb. The other gentleman never came to the marketplace, so nobody knows about him. The freedom to operate is the most important part of the patent rights. Every time your own patents are being practiced, or if you are licensing somebody else's patent, you have to ensure that you have freedom to operate. Now you have an invention. You want to take a patent. You have to meet certain requirements. What are those two requirements? There are two types of requirements: substance requirements which is subject matter, novelty, non-obviousness and utility. And second requirement is procedural requirement, enablement, definiteness and base mode. Let me explain each of these terms. When you say a subject matter, the patent has to be about something tangible. It cannot be for an abstract idea. It can be a device, a machine, a process, chemical process, metallurgical process, biotechnological process. It can be composition of matter. An alloy is a composition of matter. A catalyst is composition of matter. Your invention has to be novel. What is novel? Something which doesn't exist in prior art. What is prior art? Anything which is published. If not published, anything which is patented. Not published, not patented. Suppose it is not published, not patented. It is already in use. It is known to the people. The product is already being sold in the market. So all this becomes a part of prior art. Your invention should not be obvious to person skilled in the art. The existing body of knowledge in each subject. So whatever you are inventing should not be known to person who is skilled in the art. Third is utility. Your invention must have some use. You have synthesized a new chemical molecule which nobody has done up till now. You go and apply for a patent. It will be rejected because you do not know what is the use of that chemical. Unless you state what it can be used for. Is it a new drug? Is it a new coloring matter? Is it a new cosmetic? Then only you can get a patent. Then comes procedural requirement. All the patent documents are published 18 months after you file them. Whole purpose of publishing patent documents is that further development can go on. Anybody wants to do further R&D, the development should proceed. You get a protection for 20 years in lieu of your disclosure in the patent document. Now, for anybody to do a further development, he must be able to reproduce your invention. Your patent document should enable him to reproduce your invention so that he can do further development. Second thing is you are asking for a protection. You are claiming something. Those claims should have some definite limits. This is called definiteness. When we buy a piece of land, there is a map attached to the agreement which shows the plot, square, rectangular or whatever it is, and dimensions are given. It says this is plot number 61, front there is a road, right side is plot number 62, on the left side is plot 60 and the back side is plot number 51. So it defines the limit of your plot. Similarly, in the case of inventions, you have to define the limits of plot. You can't cover up everything. Then come based mode, the best way to practice your invention. Before we proceed further, I'd like to state that ideas and concepts cannot be patented. Very often we say, I have an idea, I want to take a patent. You can't do that. You have to show your idea works. Nobody is expecting a fully blown scale-up technology. You can do experimentation in a flask. You can do experimentation in a petri dish. You can make a prototype in your workshop. It may be made up of cardboard. It doesn't matter. As long as you can show that your idea works, you can apply for a patent. Let us look at what are the different type of patents you can get. Most commonly patents are called utility patents. Whenever we refer to the word patent, it is the utility patents. These are available for processes, machines, articles of manufacture, or a composition of matter that are deemed new, useful and non-obvious. The traditional subject matter of patents cover tangible technical inventions such as improvements to client server systems, motors, radios, computer chips and various technical product features. In addition to this, patents are now also available for business methods, which have extended the significance of patent protection to many diverse fields. Many industries that did not traditionally seek patent protection, such as fintech companies, have lately found themselves focusing their energies on building patent portfolio. For example, a method for completing a credit card transaction without the need for a physical presence of a credit card. There are different types of patents. Design patents, which protect only ornamental designs. In our country, we give design registrations. Other type of patents are design patents, plant patents, innovation patents and provisional patents. Design patents, as I explained to you, are given for the aesthetic purposes. US gives design patents to protect ornamental designs which are non-functional in character. For example, Apple has a patent covering the design of its iPhone interface. This was subject matter of one of the biggest design dispute with Samsung. In India, in most of the countries, you get a design registration. Then there are plant patents which US gives for asexually produced plants, for example, tubers, potato. Then there are innovation patents. There are many SABs which do marginal incremental improvements. Patenting system is lengthy and expensive. So innovation patents are given for such kind of inventions. They are valid only for 5 to 7 years and scrutiny is not very tight. It is scrutinized in detail if there is a dispute. Then there is a provisional patent category. In India, US and some other countries, you can get a patent application to protect your invention while the work is still in progress. Very often, we do some work, we need to share information with a vendor to get some components, sub-assemblies, we have to go to some contractor, or sometime we have completed the work, but if we don't have testing evaluation facilities, we take it to some other institutions or third parties, and we are afraid all these people will get an access to our invention and may misuse. So the system permits filing a provisional application even before the work is completed. But there is one condition. You must complete the work within 12 months by filing a complete application. When you file a provisional application, you get a priority date. And once you complete the invention and file a complete specification, your priority date remains the same, the first date on which you filed a provisional application. The legal requirement for provisional application are less than those for a complete application. You need not include claims in that application. I already told you, patent rights are territorial right restricted to grant giving country. There is no concept of world patent or international patent. You need to file in each country wherever you want a protection. Now what happens, you file in India, it takes you 3 months to file in Germany, maybe 6 months in Japan, because every document has to be translated into Japanese language. Now what happens if somebody files in between? It will create complications. So, the countries have reached an international agreement called Patent Cooperation Treaty, under which if you want to file in multiple countries, you can file a single international patent application for the purpose of getting a priority date. If you file a PCT application today, your patent will be published 18 months from today's date, and then you have 12 months to file wherever you want to file. Irrespective of when you file in those 12 months, your priority date across the world remains the today's date. So, this is a patent application, international patent application system. It is not a patent granting system. You still have to file every country where you want a protection, but for all those applications, priority date is today's. So, it protects you from other people claiming their priority. For all those people, your application will be considered as a prior art. Now, you are the inventor. Are you the owner? The international concept of work for hire. If you have been hired to do research, output of your research is owned by the people or organization which is hiring you. If I am a professor at IIT, IIT will own those inventions. I will be listed as an inventor. If you are an employee of a corporate, Tata Motors, Ranbaxy Laboratories, those companies will own your invention. You will be listed as an inventor. Now, very often we have commercial work of non-employees, say artistic work, a mural put up at the reception of a building, architectural engineering drawings, computer software. You hire an IT company to do an ERP for the organization, reports submitted by consultants, subcontractors. In all such cases, work is owned by them unless by prior agreement you say that in lieu of the compensation which we are paying, work will be owned by us. Now, very often all of us take certain actions which count against us as inventors. We go and make a presentation in the professional societies, publish the papers, there is an exhibition where we put up a stall, exhibit our invention, we distribute some leaflets, handouts, brochures, we submit our thesis to library before filing any of the patent. All these actions constitute putting information into public domain and they become a part of the prior art. And then you can't get a patent. Your own prior art will be shown to you and you will be told that there is no novelty. People have gone to the court and said, sir, it is my own thesis. Companies have said, sir, it was our own stall, our own exhibition. Courts have said, by your own voluntary action you have done this. Why have you done it? You have done it because you wanted your work to be accessible. When you put your thesis in the library, you wanted people to access it. When you put up into an exhibition, you wanted to disseminate the information about your work. Now, by your own voluntary action, you have done that. You can't come and ask for the protection. If you wanted to protect yourself, then you should have filed the patent before taking any of those actions. Even when you put invention on sale before taking a patent, our invention becomes available for public use, you lose the novelty of the invention. You can't get a patent. US is the only country which gives you 1 year grace after the knowledge comes into public domain. Currently, our Indian laws, recently we have made certain amendments. So, under certain conditions, we are going to give a certain grace period.